5 seconds to go. Start. With great reverence for the erudite opinion expressed by learned brother Pankaj Mittal Justice, I express my inability to concur therewith. The factual matrix has been noted by brother Mittal. I see no need to repeat the same except to refer thereto where required. The petitioner seeks interim bail to contest in and canvass for the upcoming general elections to the Legislative Assembly of the National Capital Territory of Delhi. The petitioner is an accused in cases relating to the unfortunate riots that took place in Delhi in February March 2020. It is averred that except for these cases, that is, two FIRs, including the present one, and ECIR number 05 STF 2020, the petitioner had secured bail in all the other cases, whereas one FIR has been quashed by the Delhi High Court. The petitioner approached the High Court, which granted custody parole for subscribing the oath and to complete the formalities in respect of filing his nomination papers subject to conditions as enumerated in the impugned judgment. It is clear that the petitioner has been permitted to file his nomination and consequent thereof contest in the election. Therefore, what this court is required to consider as to whether or not, in the attendant facts and circumstances, he can be granted interim bail to campaign canvass. The contours on which to examine the grant of bail are no longer res integra. I may gainfully refer to State of Haryana versus Hemraj 2023 SCC Online SC 1085, where this court cancelled the grant of anticipatory bail to an accused by the Punjab and Haryana High Court but revisited the precedents on grant cancellation of bail as under. This court considered the factors to guide grant of bail in Ram Govind Upadhyay versus Sudarshan Singh 2002-3 SCC 598 and Kalyan Chandra Sarkar versus Rajesh Ranjan 2004-7 SCC 528. In Prasanta Kumar Sarkar versus Ashish Chatterjee 2010-14 SCC 496, the relevant principles were restated thus. It is trite that this court does not normally interfere with an order passed by the High Court granting or rejecting bail to the accused. However, it is equally incumbent upon the High Court to exercise its discretion judiciously, cautiously, and strictly in compliance with the basic principles laid down in a plethora of decisions of this court on the point. It is well settled that, among other circumstances, the factors to be borne in mind while considering an application for bail are whether there is any prima facie or reasonable ground to believe that the accused had committed the offence, nature and gravity of the accusation, severity of the punishment in the event of conviction, danger of the accused absconding or fleeing if released on bail, character, behavior, means, position, and standing of the accused, likelihood of the offence being repeated, reasonable apprehension of the witnesses being influenced, and danger, of course, of justice being thwarted by grant of bail. The contours of anticipatory bail have been elaborately dealt with by 5-judge benches in Gurpak Singh Sibia versus State of Punjab 1982 SCC 565 and Sushila Agarwal versus State and City of Delhi 2025 SCC 1 is worthy of mention in this context despite its partial overruling in Sushila Agarwal Supra. We are cognizant that liberty is not to be interfered with easily, more so when an order of pre-arrest bail already stands granted by the High Court. Yet, much like bail, the grant of anticipatory bail is to be exercised with judicial discretion. The factors illustrated by this court through its pronouncements are illustrative and not exhaustive. Undoubtedly, the fate of each case turns on its own facts and merits. In Vipan Kumar Dheer vs. State of Punjab 2021 15 SCC 518, taking note of Daulat Ram Supra and X vs. State of Telangana Supra, the court cancelled the anticipatory bail granted to the accused therein. Keeping all the aforesaid in mind, we turn our attention to the facts in presenti. I consciously refrain from discussing in detail the evidence or my view thereon following inter alia Niranjan Singh vs. Prabhakar Raja Ram Kharote 1982 SCC 559. However, in view of the elaborate submissions advanced at the bar, reference somewhat to the materials on record is necessitated. Yet, before forming an opinion as to whether the prayer for grant of interim bail for the purpose presently sought for, that is, to campaign for the election for which his nomination papers stand submitted, can be granted, this court would have to go into the broader merits of the case subject to the caveat afore recorded. Mr. Siddhartha Agarwal, learned senior counsel appearing for the petitioner, had submitted that he would be confining himself at this stage to attempting to persuade the court as to whether in the particular facts and circumstances the petitioner would, due to the non-grant of interim bail, be seriously prejudiced and his fundamental rights as a citizen under the Constitution of India would also be compromised if he only takes part in the election as a formality, inasmuch as even after filing his nomination papers and being declared fit to contest, he would not be allowed to connect with the people of the constituency concerned and to satisfy the electorate as to why he should be elected. The thrust of Mr. Agarwal's argument was that the petitioner has been in custody for almost 5 years now, reckoned from March 2020, which is a long period, and the democratic process requires that a candidate should go before the electorate from whom he seeks votes to represent them in the body for which elections are going to be held. It was submitted that the petitioner had an unblemished record as a ward councillor, and only because of the unfortunate incidents which took place in February March 2020, the petitioner, due to certain circumstances, was named as an accused in as many as 11 FIRs, out of which in 8 he has been granted bail. What remains are the instant case and 2 other cases, including one under the Prevention of Money Laundering Act 2002, hereinafter referred to as PMLA. It was submitted that in all the cases, the basic allegation is that the petitioner was chiefly an instigator and that he may be the person who was also instrumental in logistics for the rioters. However, on identical facts in the 8 other cases, the petitioner has been granted bail, and in the remaining cases, his applications for interim bail as well as regular bail are still pending without having been finally considered on merits. Learned senior counsel submitted that under law, the right of an accused to bail is almost crystallized in the event that the prosecution fails to discharge its onus of facilitating a fair and speedy trial, which is glaring in the present case. He submitted that in the present case, there are 5 named charge sheet prosecution eyewitnesses, out of which 4 have already been examined, but the 5th witness is yet to be examined, and the ground is that the said witness has been out of Delhi on the various dates fixed in the trial. Stop.